Hey everyone, thanks so much for joining us for today's webinar, PTAB Discovery and Motions, Practice Made Perfect. We'd love for you to tell us where you're joining us from in the chat. This is the first of our PTAB Practitioner series, and Virtual Patent Gateway Principal and Founder Ashley Chung works diligently to search for practitioners to represent various aspects of PTAB practice. Virtual Patent Gateway, VPG, was founded in January 2020, right before the pandemic, and Ashley has a passion for supporting PTAB practitioners and is committed to developing a growth mindset within VPG. Today's speaker, Kevin McNish, is no stranger to the PTAB practice. A registered patent attorney, Kevin McNish represents clients in inter partes review, IPRs, post-grant reviews, PGRs, ex parte reexaminations, and other proceedings in the United States Patent and Trademark Office. He is currently the managing member of McNish PLLC. With first chair experience spanning more than 80 IPRs and other patent trial and appeal board proceedings, he is one of the most prolific PTAB practitioners in the United States. Across those proceedings, he has drafted petitions and responsive briefs, taken and defended expert depositions, and argued at oral hearings. He also maintains an active appellate practice before the U.S. Court of Appeals for the Federal Circuit, where he has both briefed and argued appeals of PTAB proceedings. This webinar will be recorded for future use, and the recording will be available to participants upon request. We've applied for Virginia, Maine, and California CLE credits for 1 hour, and they're pending approval. We'll notify you once they are approved. You're welcome to stay on camera for today's session, and there will be a live Q&A at the end of the presentation, but feel free to put questions in the chat throughout. And with that, I'll hand it over to Kevin.
Thanks for the introduction, Caitlin. So I'm excited to be presenting about this topic. This is motions practice and discovery in patent trial and appeal board proceedings. I'm looking forward to just speaking about a subject that's near and dear to my heart and something that is often much simpler than in district court, where things can sometimes, balloon out of control as it pertains to motions practice and discovery. One of the things to keep in mind about patent trial and appeal board practice is that it's very, very streamlined in two respects. First, it covers a fairly narrow subset of issues related to a patent, and in particular, patent invalidity or unpatentability. So when you're at the patent trial and appeal board in an inter partes review, an IPR, you're only dealing with anticipation and obviousness, and only on the basis of prior art patents and printed publications. Post-grant review is a little more expansive. You can cover nearly all of the conditions of unpatentability, 101, 102, 103, 112. But again, you're talking about a very narrowly circumscribed proceeding where the universe of issues is a fairly small one. Secondly, they're streamlined, not just in the issues they cover, but also in time. Patent trial and appeal board proceedings have a statutory deadline to institute trial, that is to decide whether to go forward with a full-blown inter partes review, from roughly 6 months and change after filing the petition. The and change comes from a notice of filing date accorded that the Patent Trial and Appeal Board only enters after it confirms the petition complies with the formal requirements. But you've got 6 months and change from the petition filing date to the decision to whether to institute trial. Once that's in place, there is a 1-year deadline for the Patent Trial and Appeal Board to complete proceedings. So you have a very compressed time frame relative to most district courts, Western District of Texas being a notable exception. And that really guides a lot of why the Patent Trial and Appeal Board is relatively limited in its motions practice and in its discovery practice compared to what you would typically see in district court proceedings. So we're going to cover basically the principal forms of motions, the types of motions that can take place in patent trial and appeal board proceedings. First, we're going to go through just the very, very basics, and you'll see how the Patent Trial and Appeal Board's emphasis on streamlining really informs a lot of the mechanics of motions practice before the PTAB. We'll also cover why you would want to file a motion, and that includes things like obtaining discovery, adding or subtracting papers or exhibits from the proceeding, addressing related patent office proceedings, and miscellaneous motions. Finally, we will hit appellate review and appellate review of motions practice at the federal circuit. It's, again, relatively circumscribed compared to what you might see in district court, but it is something to know, especially because there are some motions where, if you do not get the relief you're seeking at the Patent Trial and Appeal Board, you may need to seek further review, not just from the Patent Trial Appeal Board, but also the Court of Appeals for the Federal Circuit. So let's start with just the very basics. Why do you want to file a motion? So in order to file a motion, you need to be seeking some kind of relief. And that's relief other than requesting that the board institute trial, because that's what's in the petition. So essentially, to think about what you're looking for is essentially anything that you want to do or that you want to have done for you that you don't already get to do as of right, or that the board hasn't already pre-authorized. So think of it pretty broadly, and sources of things that you're already allowed to do include things like 37 CFR 42. That's where you get most of the regulations related to Patent Trial and Appeal Board proceedings. 35 USC 311 and subsequent statutes, and also 321. Those are the IPR statutes and the post-grant review statutes, respectively. Those often provide you certain rights, things you can do anyway as of right, as well as the Consolidated Trial Practice Guide, which is something you're going to be hearing about a lot today. And that is a document promulgated by the Patent Trial and Appeal Board. It's roughly, the best way I can describe it is it's like the manual patent examining procedure, but the PTAB contested proceedings version of that, where it's going to provide certain things that, while they don't necessarily have the force of law, generally reflect how the Patent Trial and Appeal Board are going to approach various facets of the proceedings. So if you want some relief, you need to ask for it by motion. But in order to ask for it by motion, you actually need to get permission, authorization from the Patent Trial and Appeal Board to actually file that motion. And this is a pretty major part of departure, point of departure rather, from district court practice. District court practice, when filing a motion, you meet and confer, you exchange some number of increasingly nasty emails, depending on your opposing counsel, and then, you join the issue and then you file. Patent Trial and Appeal Board is very different. You still have to meet and confer, but you actually need permission from the board. That permission, getting that permission, is a process. It's a multi-step process, so you need to start quickly. You need to move quickly while you're trying to do that, because if you don't do that, if you don't move sufficiently timely, you may not get the relief you need in time, or the board may say, look, it's too late, you moved too slowly, and something is, we're up against some deadline ourselves as the Patent Trial Appeal Board. We're up against a deadline to enter an institution decision. We're up against a deadline to put in a final written decision. So it's just too late. So start early. The other thing to keep in mind is obtaining authorization requires some degree of cooperation from your opposing counsel, as we'll discuss in the next couple slides. Civility, while important in district court, is even more important before the Patent Trial and Appeal Board, in large part because of that. The Patent Trial and Appeal Board bar is also much smaller than the patent litigation bar, which is already a pretty small bar. You can get a reputation pretty quickly, and generally you're going to want to develop a favorable one, again, because cooperation is often required. So the first thing you need to do in obtaining authorization for a motion is to meet and confer with your opposing counsel. For any motion that needs authorization, the board expects the parties to meet and confer before the movement requests authorization. You're not necessarily going to see that in the regulations. It's not necessarily in the trial practice guide, with the exception of discovery motions, which do require a meet and confer. But it is very much a best practice to meet and confer. The goal of the meet and confer process is to narrow the issues as much as possible. And by narrowing the issues, you need to come in with your sort of final and best offer. Both sides really need to get to their final and best offer with respect to the relief requested. For instance, if you're looking for permission to file an added brief and one side says, well, I don't want you to file at all, and the other says, I want 10 pages. If it turned out the parties might have agreed on 5 pages, the Patent Trial and Appeal Board doesn't want to find that out for the first time on the conference call with the board, which comes a little bit later. Narrow the issues as much as you can, have a good, meaningful discussion, and once you've really narrowed the issues as best you can, then, only then, start moving the process of requesting a conference call forward. You need to find out when your opposing counsel is available for a conference call with the board. This is essentially a mini hearing where you attempt to persuade the board that the motion should either be granted or authorized or not authorized. Generally, give the board at least 3 times and give the board some lead time. A couple business days worth of lead time is expected. I would say at least 3 to 5 days at the bare minimum. And give them a couple times as well. Specify the time zone. Not all of the judges are on the same time zone. You can have them in Eastern time. They're actually across all 4 time zones. So in Alexandria, in Detroit, they're on Eastern time. In Dallas, they're on Central. Denver, they're on Mountain. And San Jose, they're on Pacific. So state the time zones so that there's no confusion and it's pretty clear which time zones you're offering to the board. So once you've done that, once you've narrowed the issues, once you've come up with a set of times for this mini hearing with the board, the next thing you need to do is email trials@uspto.gov to request a conference call about the motion. It needs to be a non-argumentative email. If you go to any bench and bar conference or any time where you have a patent trial and appeal board judge asked about their pet peeves, top of the list is almost always argumentative requests for a conference call. And the reason for that is it's essentially an unauthorized brief that you didn't get permission to file. And discovery fights aren't why the PTAB is there. Motion practice fights aren't why the PTAB is there. They're there to adjudicate patentability. So, the question often comes up, how do I provide a non-argumentative request for a conference call, and what do I do if the other side gets argumentative? So to answer the first question, non-argumentative doesn't mean no context. Essentially, you don't want to go too far, but the board does need a little bit of context to understand why you want to file a particular motion. You might just say something like, in light of X, my client wants to do Y, or, request authorization to move for Y, and that's okay. If you get too much further than that, you're going to start getting into argumentation. But if you want to say, here's the context, and here's why it's relevant, that's it. It's relevant to our contentions, or it's relevant to the other side's contentions, and we need this motion. Much further than that, though, you're going to be in the realm of argumentation. If the other side sends in an argumentative email, it's often a dilemma because you don't want to be argumentative, but at the same time, you don't want the other side to get the only word in or to make it look like you don't have anything to say. So it's sort of a tricky balance there. Probably your best option is to reply to the email because the other side, the party emailing the board to request a conference call, is required to CC you and to simply state, look, we don't agree with those arguments. We don't agree with those characterizations. We'll be prepared to address on the conference call. And that's it. Leave it at that. Don't escalate. Certainly don't escalate because that invites further argumentation, and that's going to just make the Patent Trial and Appeal Board even more angry. Speaking of contentious proceedings, every now and then you'll get a breakdown in relationship with opposing counsel where something happens, somebody emails the board, somebody, deliberately, and unfortunately it does happen, or even inadvertently emails something that doesn't reflect, emails the board with a request, and maybe it doesn't reflect the substance of the party's positions that they've met and conferred about, or doesn't reflect an issue right. Oftentimes it's a good practice, but not a strictly required one, to actually just email the other party first before you request the conference call and say, hey, we've met and conferred. Here's what we're going to email the board. And that's it. And just be very factual about it. Set an exploding deadline within, maybe 2 or 3 days, and then email the board. But, not required, but sometimes in dangerous, especially contentious circumstances, it can be valuable. Okay, so the next thing you're going to want to do, especially if it is your motion that you're filing, is to retain a court reporter for the conference call. If you are the one making the motion and you're the one requesting the conference call, you should definitely request a court reporter. And the reason for that is you want a transcript, right? You need something that memorializes that you actually raised a particular issue and that you put the board on notice of the substance of the issue. And you need to do that because it may be the only record of your efforts to obtain relief. The board may simply rule on the conference call, and if you don't have anything that shows that you argued a particular point, it becomes a lot harder to show that you preserved a particular issue for appeal or that you previously raised an issue in advance of a request for rehearing at the board. So the next thing you need to do is get on the conference call. You'll get an email back from a paralegal at trials@uspto.gov. Dial in a little bit early just to confirm your court reporter's there. And one thing you should notice, during that sort of early silence before the call, the board is often dialed in, and they may not have announced themselves until the actual time set for the conference call. So they may be there, you may just not hear them. Let me jump in. Are there any I just had a question come in the chat. Are there any circumstances when you would not want a court reporter for a board call? So my general view is if you're the one making the motion, you should definitely bring a court reporter. If you're not the one making the motion and the other side has not brought a court reporter, I wouldn't necessarily bring one, especially if you think you're likely to prevail on the motion. Again, the principal reason you want that is to show that you've demonstrate that you've preserved an issue either for a request for a hearing or a subsequent appeal. So back to the conference call itself. Be prepared to argue not only why the board should authorize your motion, but why you should win that motion, and understand that those are two distinct issues, right? So authorizing the motion is why you should be allowed to file it. Why you should win is usually reserved for the substance of the motion yourself. You can and should bring that up a little bit, but the principal issue is why should the board authorize your motion? Why do you need this motion to essentially justly present your case? Let's see, another question from the chat about court reporters. Do you usually confirm with the other side that they're bringing one? I don't typically ask. Though, if it gets close and you haven't heard anything, probably not a bad idea to ask. I will usually, if I'm bringing one, say, hey, we're bringing a court reporter to this. And so the reason for that being, you don't want to bring duplicate court reporters. It's just a waste for everyone involved. All right. And then finally, congratulations, you have gotten through the conference call. Usually after you have your little mini hearing with the board, they'll go on mute for a while. It can be 10 minutes, it can be half an hour. And then they'll either authorize the motion or deny the motion. Sometimes that'll follow with a written order, sometimes it won't. They'll usually set a briefing schedule as well. If things didn't go the way you wanted on the conference call, you can request rehearing, which is generally good. Generally something you should do for motions pre-institution or that don't necessarily bear on an issue that's going to be baked into the final written decision. Or you can do it by raising the issue during a subsequent appeal. There are some motions that don't require prior authorization. Those are things like motions filed with a petition, motions to seal, motions to exclude, motions for pro hoc admission, and motions for additional discovery, although there's a bit of a question mark about that. And the reason being that the regulations explicitly state that a motion for parties may move for additional discovery. At least one panel of the Federal Circuit has found in a non-precedential opinion that means the board has to authorize additional discovery motions, but it's a little bit in question, and you should probably still request authorization just to be on the safe side. Uh, just briefly, we're going to talk about formal components of a motion. No omnibus motions, one subject at a time. A motion must include the things you would expect it to include, statement, what relief you want and why you should get it. Optionally, you can include a statement of material facts and numbered paragraphs. I don't typically see this. It's relatively infrequent. In fact, usually the only time you see it is in pro hoc motions, where there's a pretty detailed set of regulatory requirements you have to comply with. And you've got 15 pages by default for an opening motion and an opposition. Replies are limited to 5 pages. All right. So next we're going to talk about discovery motions. And again, just remember that discovery is very narrowly circumscribed at the Patent Trial and Appeal Board. We're going to first discuss the framework for taking discovery by motion at the Patent Trial and Appeal Board, and then secondly explain why you maybe shouldn't actually try to get discovery at the PTAB, because there's better ways to get it. So again, Patent Trial and Appeal Board discovery is very limited by design. The goal being to secure the just, speedy, and inexpensive resolution of every proceeding. Congress was concerned about discovery costs and how much they slowed down district court litigation, and thus, when designing AIA proceedings like IPRs, like post-grant reviews, they limited discovery. There are two principal flavors of discovery. One is routine discovery, and everything that isn't routine discovery is additional discovery. Unless the parties agree otherwise, all discovery that isn't routine discovery requires a motion. Now, there is an example of pre-authorized discovery called so-called voluntary mandatory initial disclosures. In that process, if the parties can agree before the patent owner files its preliminary response on a certain set of discovery, they can actually obtain pre-authorized discovery. I will tell you, though, I have done 80-something IPRs, and I have never seen this before. I have asked many of the most experienced practitioners out there. I've asked, have you seen this? Do you do this? Almost unheard of. So routine discovery, additional discovery are the two things to focus on. You're not really going to see much in the way of mandatory initial disclosures. So routine discovery is, again, things that you are automatically entitled to discover from the other side. One of those categories is any exhibit cited in a paper or any exhibit cited in testimony, unless it's been served already. So, when you're filing a brief, make sure to include all the evidence you're citing. If your expert is citing something, make sure to include everything your expert is citing. All of that's available as routine discovery. So just make sure that, when you're filing your brief, you're filing your expert declaration, include everything that it cites, unless it's already of record in the case. The next part of routine discovery is cross-examination of affidavit testimony prepared for the proceeding, better known as PTAB depositions. So that prepared for the proceeding actually does a lot of work in this regulation. So there is not, for example, routine cross-examination of affiants who have testified during prosecution. This happens a lot during life sciences cases, where maybe the patent owner has put up an expert during prosecution that says, well, we had some unexpected results from this new drug formulation. That's actually not available as routine discovery. Might be available as an additional, but not available automatically as routine discovery. Affidavit testimony prepared for the proceeding also doesn't include testimony prepared for litigation. And so, for instance, in the particular case I've got cited on the slide here, there was an expert that had testified for the plaintiff in a preliminary injunction hearing and had given an affidavit addressing some of the invalidity contentions that the petitioner defendant in the district court litigation had made as to respond to the motion for PI. And that's actually not again, routine discovery, because it was prepared not for the PTAB proceeding, but for the district court litigation. So routine discovery not available in that case either, might be available as additional discovery. Finally, there's one last category of routine discovery, which is information inconsistent with a position advanced by a party during the proceeding. This isn't just a discovery obligation, this is a duty of candor obligation as well. Generally, if you think that there's something you've got that might be purportedly inconsistent. Oftentimes, it's best to just disclose it and get out in front of it. Control the narrative. Don't have the other party say, hey, they violated their routine discovery disclosures. We know they're hiding something. We're going to move to Appellate. Oftentimes, it's much better to say, we have nothing to hide. Here's this document, and it doesn't affect what we're saying. We still win anyway. So we've got a question, example of inconsistent information that I've seen. Probably the most egregious example I've seen was in a patent owner response that contended that references that were asserted in the petition didn't disclose various limitations. Now, in the litigation, the patent owner actually had to serve validity contentions in which it had to admit or deny on a limitation by limitation basis whether these same references actually disclosed those limitations. And it turned out that in the litigation, the patent owner in those contentions had admitted that all of those limitations were disclosed. Now, it didn't have to take routine discovery of that because it was a public litigation document already in our possession, and it was flagrantly inconsistent. But that is probably kind of the smoking gun there. Oftentimes you see relatively little litigation over this particular issue because oftentimes the opposing party actually already has that document in their possession for one reason or another. So continuing to additional discovery, consistent with the limitations on discovery in patent trial and appeal board proceedings, additional discovery is only available in interest of justice and IPRs and available for good cause as long as it's relevant to an assertion advanced by either party in a post-grant review. Nominally, those are two different standards. As a practical matter, though, they've more or less converged. Especially because in determining whether additional discovery is in the interest of justice or if it's available for good cause in post-grant reviews, but the same framework is used for both. So there's a 5-factor test for obtaining additional discovery. I'll go through each factor briefly. So for the first factor, more than a possibility in mere allegation, this is essentially a no fishing expeditions factor. You don't need a smoking gun to show that there is some kind of document or some kind of discovery that is beneficial to you that the other side has. But you need to show that where there's smoke, there's some fire. You ideally have some information already in your possession that suggests that there's more that the other side already has. Turning to litigation positions and underlying basis for those positions, this is basically a no contention rogs, no contention depositions factor. And the reason for that being trials carried out on the papers, you don't need to discover the basis for any position because if it's not in the papers, it's just not there. Ability to generate equivalent information by other means. Is it publicly available? Do you already have information in your possession that would help? Is there some why do we need to get this from the party you're trying to seek discovery from? Easily understandable instructions. District court practitioners may be familiar with, interrogatory requests or document requests where there are, 5, 6, 10 pages of instructions and defined terms. Don't do that at the Patent Trial and Appeal Board. It's just too complicated. It's going to be held against you. And not just under that factor, but also under the next factor, request not overly burdensome to answer. So, not overly burdensome to answer, that all refers to keeping the instructions simple. It also means to very narrowly circumscribing what you're actually seeking. For instance, think about if you're a patent owner, you're trying to get discovery about an accused product because you think it embodies a particular feature whose commercial success demonstrates that your claims aren't obvious. You could ask for all documents about the accused product. Well, that's going to be pretty burdensome to answer, and that's likely going to get denied. A better approach might be to say, hey, I know that they've been marketing this particular feature that lines up with our claim limitations. Let's find out more about their marketing strategy from a particular time period related to this particular feature that is really kind of the crux of our non-obviousness case. So keep it narrow in subject matter, keep it narrow in time, and you're more likely to obtain favorable treatment under that framework. Finally, there's a third mechanism for discovery at the Patent Trial and Appeal Board. It's an application for a district court subpoena. These are subject to the additional discovery framework. They are also almost never used, at least not these days. And the reason for that is the most common use case was to subpoena an author, a librarian, a publisher, something to prove up or disprove the public accessibility of a non-patent reference, like a conference paper, like slides presented at a conference, a book, a journal article, that kind of thing. The reason that use case has fallen out of favor is that these days there's a small industry of librarian experts who can actually do that for you. You reach out and they'll go through the Library of Congress, they'll go through University Library of Records, and they'll say, hey, this was shelved and cataloged as of some date that qualifies this reference as prior art. Oftentimes also you can just reach out directly to the publisher and sometimes they'll help you. IEEE and ACM are both publishers of many different journals, and they have folks whose role is largely to actually give declarations about this. They're publication managers, and they'll often, if you ask nicely, will simply give you a free one. So the same is true of the Wayback Machine. That's another example. So you found yourself in a position where you need some discovery, and the question then becomes, do you want to move forward at the PTAB, or do you want to try to obtain it some other way? And I'm going to recommend that usually you want to obtain it another way, but think about, if you have to go through the PTAB, what you want to do. For your discovery requests, design your ideal document. What is the perfect document that you want? And then work backwards. Design the simplest, shortest, and fewest discovery requests to obtain either the documents you want, the interrogatory responses you want, or in some circumstances, the deposition you want. Keep things as simple, short, and few as possible for your discovery requests, and the easiest way to do that is work backwards. Narrow what you want from discovery to the very smallest universe of stuff you need. For the motion itself, again, you've got 15 pages. Generally, again, you're going to want to show that where there's smoke, there's fire. You've got some information that suggests there's more good information out there. Show that. Stick to the facts as well. Don't accuse the other party of hiding things. If you've got adverbs in there, something probably went wrong. So again, just keep it very, very straightforward, just the facts, and that will more likely ensure favorable treatment of your discovery motion. But then the question becomes, do you actually need to move for discovery at the PTAB? Do you need to go through the whole process of obtaining authorization and then maybe getting your motion denied at the end of it, or getting authorization denied, and then having to, you've got ways of getting documents that don't require discovery at the PTAB. One of those ways to obtain is the evidence you need already publicly available? Can you get it from Public PAIR, which is the Patent Office's system for publicly displaying documents related to patent applications? Can you get it from PACER, which is the public repository of litigation documents? Is there some kind of document that the other side has filed in your case publicly that you can just use? Can you go to EDGAR? EDGAR is a repository of SEC filings, and oftentimes you can find discussions of mergers and acquisitions, which can be related to real party and interest considerations, which we'll get to in a little bit. So just think broadly about public sources of the information you're looking for, and maybe go that way instead. Another question is, can a friendly witness willing to sit for a deposition get the evidence to you? Again, if you're going to submit testimony, the proponent needs to sit for the deposition. So if you've got someone that'll do that, use that witness. And finally, can you get, or do you already have that evidence from co-pending district court litigation? Just a word of caution about using district court litigation materials. You do need to obey the protective order. And if you don't, there are consequences. So as an example, there was a plaintiff that tried to use some materials produced under a protective order in district court litigation to try to obtain PTAB discovery. That actually resulted in sanctions in the district court because the protective order said anything produced here is used for this litigation and this litigation only. So usually the best approach is, approach the other party for permission and say, hey, we want to use this at the PTAB. And if they don't agree, move the district court for relief from the protective order so you can use those materials at the PTAB. And district courts like that. District courts really usually prefer to actually have those materials go in front of the PTAB, especially if they're thinking about staying in the case or already have, because they want to make sure there's a complete adjudication taking place there. So sort of this parenthetical quote about encouraging parties to do that, that's typical. That's actually a very typical attitude for district courts. So next, we're going to turn to motions addressing papers and exhibits. In other words, how to add things that aren't already allowed to be added, or how to remove things that shouldn't have been included in the litigation, in the PTAB rather. So the first is supplemental information. Supplemental information is essentially anything that you're not going to submit with a principal brief. That is, your petition, your patent owner, preliminary response, patent owner response, petitioner's reply, that relates to some kind of issue in the proceeding. Oftentimes that's district court claim construction orders or litigation documents where you've used up all your principal briefs and you don't get to file evidence as of right. There are some rules. There's a timing framework for submitting supplemental information. Usually you need to do it within a month of the institution decision. If you do it after that, you have to show that there was no way you could have submitted it earlier, and it's in the interest of justice to consider it. So again, though, oftentimes you don't need to go through that process, and the reason being, there are many briefs where you get to file evidence as of right. Again, principal brief, patent owner response, petitioner reply, petition, preliminary response. Oftentimes you can just skip the process, file it with your brief, and then cite it, because presumably you're not going to include that information unless you're going to use it. And it's important to understand the difference between supplemental information and supplemental evidence. Supplemental information goes to the merits of the case. Supplemental evidence goes to the admissibility of other evidence. And supplemental evidence comes up in the context of motions to exclude. So the federal rules of evidence nominally govern PTAB proceedings, and I say nominally because the PTAB as a whole is generally more likely to favor admitting evidence than I think your average district court would. You'll see a lot more use of the residual exception to admit evidence, the residual exception to hearsay to admit evidence at the PTAB. You'll also see a lot more use of the ancient documents exception to get evidence admitted at the PTAB. But if a party serves evidence that you want to object to, you've got 5 business days, that's business days, not days, business days to object, and you need to file those objections, serve them on the proponent. The lone exception is for evidence submitted before the institution decision. You've got 10 business days after the institution decision to object. Objections should be pretty straightforward. Usually what I do is a chart with multiple columns. First column is the exhibit number. Second column is the rules of evidence I'm citing as the basis of my objection. And the third is a short prose explanation of why I think this evidence is objectionable. So, keep it simple, but you do need to put the other party on sufficient notice so that they can serve supplemental evidence to try to cure the objection. And where an objection has been lodged, the proponent of the evidence has 10 days to serve, but not file supplemental evidence addressing the evidentiary objection. So again, supplemental evidence, addresses the admissibility of other evidence. Oftentimes it can be things like a declaration to authenticate a particular exhibit. That's probably the most common one. There are other examples, but I'd say that's the most frequent use case. So when you serve supplemental evidence, you actually don't file it at first. What you should file, you simply email it to opposing counsel if they've consented to electronic service. What you should do, though, is file an updated exhibit list with the Patent Trial and Appeal Board listing the exhibits you served as supplemental evidence, and then with a notation, served not yet filed, and then a certificate of service proving that you've actually, or attesting to rather, that you have served the supplemental evidence in a timely fashion. So once we get to motion to exclude briefing, this only occurs at the end of, or toward the end rather, of an instituted Patent Trial and Appeal Board proceeding. You have to have made some previous objections to preserve your right to file a motion to exclude, either by objecting to exhibits, or if you are defending a deposition, objecting to deposition testimony, but you have to have timely made those objections. There are also some formal requirements as well, and you can see those on the slide. It should be, you've got to go in order is kind of the big one. And then finally, a party opposing a motion to exclude. This is when you get to file an opposition as of right. That's on the next due date 5. And that's when you file your supplemental evidence that you previously served, and then you can cite that to respond to the objection. Now, in some cases, you may find yourself in a scenario where you served supplemental evidence, but then later actually relied on that evidence to go to the merits in a brief. For instance, let's say there's some kind of dispute about the admissibility of a non-patent reference. The petitioner has served some kind of non-patent reference, that's served some supplemental evidence, and then they're continuing to argue about it in their reply brief, their petitioner's reply. They may end up filing it with their reply, and then they can then rely on it later in the motion to exclude briefing. One other note about motion to exclude briefing is the PTAB usually likes to address admissibility of evidence to the extent it can before the oral hearing. So usually what you'll often get is a pre-hearing conference with the Patent Trial and Appeal Board a couple days before the oral hearing. Either party can request it. Sometimes the board will set it sua sponte. And that's where the parties can address the evidentiary issues or any other threshold issues, because the board really just wants to focus on the substance of the case, the patentability matters at the oral hearing itself. Motions to strike are also a type of motion that can be used to remove papers as opposed to removing exhibits from a Patent Trial and Appeal Board proceeding. Rarely filed these days, even more rarely granted. The principal use case is addressing untimely new arguments. If you are a patent owner, though, oftentimes if you see new arguments in the petitioner's reply that are sort of beyond the scope, that aren't responsive to what you said in your patent owner response, but introduce new theories, generally the better approach is actually, instead of saying, hey, I want a motion to strike, is to just say in the SIR reply, hey, this is an impermissible new argument. This goes beyond the scope. So, you need to move very, very quickly on motions to strike, just because you're starting to get toward the end of the proceeding, toward the oral argument, and PTAB starts getting very compressed timeframes there. And generally, the board will only rarely strike briefs, and you need to show some extremely severe prejudice. So really, motions to strike should be rarely used. If you're a patent owner, you probably shouldn't use them because you can simply raise the new argument issue in SIR reply. Petitioners, I think, will be more likely to use them, and the reason for that is if the patent owner does a whole bunch of new stuff in its SIR reply, you can then say, hey, these are new arguments. We didn't get a chance to put a paper in on them. That said, again, motions to strike rarely granted. There are some better approaches. One is to ask the board for permission to file a list of arguments that you believe are improper, and then just leave it at that. And sometimes the board actually prefers that rather than litigating a whole motion to strike. And the other is to request an additional brief to address any allegedly untimely new assertions. So keep those in mind. Motions to strike, again, don't count on it getting granted, and oftentimes there's better ways to get the relief you really want. Motions to seal, these are another, a little more complicated than district court. Parties need to meet and confer on a protective order first, and the first motion to seal needs to be accompanied by a protective order that the parties have agreed on. The board generally prefers the default protective order. They will allow modifications if you demonstrate good cause. For instance, maybe you've got some source code, maybe you've got some HIPAA protected information that warrants higher protection than the default protective order. You also need to submit a red line against the default protective order, and you can define the default protective order in the Patent Trial and Appeal Board's trial practice guide. So just as a practice tip, there are 4 factors you need to address in any motion to seal that you file. Do this very, very rigidly, because the Patent Trial and Appeal Board will judge your motions very, very rigidly. Go through each factor, for each item, go one by one per factor. You're allowed to group items if the same reason applies to all of them for sealing them. For instance, if you've got a bunch of source code modules that all relate to a single attempt to swear behind, and it's all related to the same product, that would be an example of a reason for grouping them. Oftentimes, it's a good idea to file concurrently filed public redacted versions. That will help address the balance between keeping a clear public record and the need for confidentiality. Necessary, not usually sufficient, though. Oftentimes, you're going to need to give a non-confidential summary of what you're trying to seal in your motion to seal. Finally, panels often vary if you're trying to seal somebody else's information, and that will often come up in scenarios where you're filing a brief addressing some confidential evidence that the other side has submitted. Some panels will want you to file the motion to seal. Other panels will actually want you to have the party whose confidential information it is file the motion to seal. When in doubt, confer with your opposing counsel, work it out, request guidance from the panel, just get a conference call in and try to understand, what precisely they want you to do. And, that's actually a fairly common situation. Oftentimes a patent owner will use confidential materials to try to swear behind something, and, it's probably the most common use case. But you also see it come up when a petitioner, there's some kind of real party and interest dispute, and the petitioner has some kind of agreement with someone else that might be confidential and bear on the proceeding. And finally, motions to expunge. This is where confidential information is removed from the record at the end of the proceeding. Anything cited, discussed in the final written decision will usually become public by default, so think carefully before you submit something you want to keep confidential. The other thing is, sometimes you'll have an appeal from a final written decision. In that case, you can move to preserve the record. That'll just maintain the status quo of sealing until the Federal Circuit gets to a final decision. I want to briefly touch on motions addressing related patent office proceedings. The most common of those is a motion for joinder. And a party can join an instituted proceeding or one that will be instituted, or to be instituted rather, by filing its own IPR or PGR petition, followed with a motion for joinder. Now, the motion for joinder can only be granted if the first proceeding is actually instituted, but you don't have to wait for it to be instituted to file. You can actually file beforehand. And the reason for that is, there are some timing requirements. It has to be filed no later than 1 month after the decision to institute the previous proceeding. For IPRs, the petition that you file as the joinder petition has to be identical in substance to the first petition. Can't add new claims, can't add new issues, can't add new arguments. Has to be the same. Just some more practice tips on that. Be prepared to accept an understudy role in which the first proceedings petitioner takes control of everything. Signs off all the briefs, takes care of principal responsibility. And the reason for that is, you don't want to be an excessive burden on the patent owner. Keep in mind that the discretionary factors bearing on institution apply to joinder petitions to the same extent they apply to original petitions. The facts may be different, but the discretionary framework still applies. So if the facts are different between, say, your petition and the other petition as it pertains to the board's discretionary ability to deny institution, either because of previous petitions or because of an impending district court trial date, that's a good place to address in your motion for joinder. Because again, you don't want to be injecting new issues into the petition. You need to keep the technical issues the same. The Patent Trial and Appeal Board can also take jurisdiction over other proceedings involving the same patent, not related patents, not related applications, but the very same patent in the Patent Trial and Appeal Board. Typical use cases, a petitioner will often try to stay patent owner filed re-exams or reissues to prevent inconsistent results. Patent owners, on the other hand, will usually use this to try to terminate re-exams against patents that are already subject to an IPR out of fairness and just avoiding burdening the patent owner. Again, this is a pretty rare circumstance, and an even more rare circumstance is where the patent owner will actually move the Patent Trial and Appeal Board to cede its exclusive jurisdiction to get a certificate of correction issued. The reason this is rare is patent owners generally prefer to have as clean a patent as possible before they go out and sue someone and then get an IPR filed against them. And keep in mind that if you are a patent owner doing this and you do obtain a certificate of correction, it cuts off all past damages as to the corrected claim. So oftentimes it's much better to just take care of this in advance before filing, address it, and then move forward with the litigation. Finally, I want to get through some miscellaneous motions. Pro hoc motions allow attorneys without reg numbers, not admitted to practice before the USPTO, participate in a PTAB proceeding. They can do anything someone with a reg number can do except be lead counsel. There is a pretty lengthy affidavit required attesting to things like where you're admitted, your good character, you've never been sanctioned, you know the patent, you know the file history, etc. And the case, you'll get a copy of these slides, but the case I've cited in this is sets out the list of requirements. Just as some practice tips, it's a good idea to secure opposing counsel's non-opposition before filing. And finally, timing really matters with these. Don't file one the night before an oral hearing, for instance. It'll take the PTAB some time to pick these up. One kind of interesting practice trick I picked up over the years is that you can actually use pro hoc motions to discover who your panel is, sometimes before you would ordinarily. Normally, the first time you find out who your panel is at the institution decision, but if you file before the institution decision, sometimes they'll pick up the pro hoc motion, decide it, and now you know who your panel is. So if you're a patent owner, you can sometimes find out who the panel is by filing a pro hoc motion before your preliminary response. If you're a petitioner, usually the best time to do it is immediately after the patent owner's preliminary response. And the reason you often want to know who your panel is panels can vary on how they treat discretionary denials of institution or other issues. It can be a little idiosyncratic. So if you know who your panel is, you can tailor your briefing accordingly, and that will often help you. Motion for sanctions, I won't spend a ton of time on these just because at the PTAB, we're generally a pretty well-behaved lot. There are two heads of authority for sanctions. One is like Federal Rule 11. It only applies to briefs and only applies to signed briefs, rather. The other is 37 CFR 4212, not limited to signed written submissions, covers more forms of misconduct, in particular deposition misconduct, or in one particularly memorable case where a series of ex parte letters were being sent threatening PTAB judges with RICO charges and other criminal allegations in a case that got a little bit of press coverage as well, and my prior firm was involved in some of the district court litigation on that. So again, it's not limited to signed written submissions, covers anything that Rule 11 doesn't, but in some cases, the same misconduct will be sanctionable under both headings. Sanctions motions also need to be brought in a separate motion from any other motions. The omnibus prohibition is especially strong when it pertains to sanctions motions. Finally, to actually settle a case, it's more than just filing a voluntary dismissal like you would in district court. You actually need to get authorization to terminate the proceeding. And then to actually do that, you file a joint motion, both parties sign it, and you will also need to file any settlement agreement and any related agreements that bear on the particular proceeding you're settling. And you'll need authorization to file that confidentially and kept separately from the patent file. It's essentially two different motions, and you use both of them to settle a case. Finally, for anything not covered by the regulations, you can just ask for it. Just ask for it. And if it's reasonable, the PTAB will often grant that request. Be sure to discuss with opposing counsel first for any miscellaneous relief you're looking for. Finally, just briefly discussing appellate review. First, preserving the issue. Generally, obtaining authorization is often enough. But this is why you want the transcript. You want to demonstrate that you sought authorization, you put the board on notice of the issue. If you filed a brief, usually that's also enough. Requesting rehearing, usually not necessary to preserve an issue, but if you are attempting to get relief on something that can't be appealed, and typically that is trying to obtain something that relates to the institution decision, which aren't appealable, oftentimes you'll want to file a request for rehearing. Finally, address the decision denying your motion in your notice of appeal, your docketing statement, and your opening brief to the Federal Circuit. Just best practice to make sure that you've preserved the issue all the way through. The standard of review is abuse of discretion for motions related to the PTAB's management of a proceeding, which is most procedural motions. Evidentiary rulings also reviewed for abuse of discretion, and there are 4 possible abuses of discretion out there. Of those, the least deferential is erroneous conclusion of law, but you really need to show that it is a legal issue as opposed to an application of law to fact in order to really have a good chance of getting that to stick.